Hi, my name is Fazil Jamal. I'm an assistant professor of international law at the Jawaharlal Nehru University in New Delhi. As part of the course on international human rights law, today we shall discuss the module on rights of the child under international law. The structure of the lecture is as follows. We discuss an interesting fact emerging from the Eastern legal tradition, its distinct contribution to the evolution of the rights of the child, in due course even influencing the development of the Western legal tradition. And then we follow it with a discussion of the international legal framework for the rights of the child, especially the UN Convention on the Rights of the Child and its 3 optional protocols, and also the institutional mechanism which has been established under the UN Convention on the Rights of the Child. This is followed by an evaluation of India's commitment and compliance with those obligations under the rights of the child. And we conclude with certain observations regarding the trajectory of legal developments on the rights of the child. As we know, rights are moral entitlements or other claims of interest of individuals and other entities that are socially recognized and legally enforced by the state and its agencies. The idea that children are capable of possessing rights and other entitlements has a longer tradition in the Eastern world. Consider, for instance, the Islamic legal tradition, where the requirements of obtaining the child's consent for marriage, the concept of an option of puberty by a person who has come of age to reject the decision taken by adult guardians, the rights of child to maintenance, to shelter, and to a fixed share of inheritance in the family property, etc., point to the recognition of child's special needs and vulnerable position, evolving capacities, and independent entitlements. On the other hand, for a long period of time in the Western legal tradition, children were seen as quasi-property of the parents, and the courts were reluctant to enforce or interfere with inside the family matters, or as considered to be the domestic sphere. However, with increasing awareness about the issues of children, laws began to be enacted to protect children's rights in many countries. Children as a subject of international law has come to have rights and obligations, mostly entitlements, because of their special and vulnerable position. International law today recognizes inherent dignity and the equal and inalienable rights of all human beings, all members of the human family, including children. The child has a status as a subject of rights and entitlements, and as a human being with dignity and evolving capacities. International law recognizes the children's special and dependent status, and that these status may create real difficulties for them in the enjoyment of their rights and also in pursuing remedies for the violation of their rights. With the growth and the progress of transnational human rights movement in the last century, rights of the child began to be embedded in and recognized under various sub-disciplines of international law. For instance, not just international human rights law, but also international humanitarian law talks about the rights of the children. International refugee law has special components dealing with the question of the refugee children. International labor law recognizes the problem of child labor, and international criminal law criminalizes the practices associated with armed conflicts where children are used as soldiers or for other practices. The purpose of legal interventions vis-a-vis children is to ensure that their healthy and normal physical, mental, moral, spiritual and social development in conditions of freedom and dignity. Hence, general international law instruments such as the Universal Declaration of Human Rights, the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social and Cultural Rights, the Convention on the Elimination of Discrimination Against Women, the European Convention on Human Rights, the African Convention on the Human and People's Rights, the UN Disabilities Rights Convention, etc., contain many provisions that refer to the rights of the children. Entitlements, safeguards, and also as members of the human family, these rights are available for children in their varied settings. For instance, the Universal Declaration on Human Rights in its Article 25, paragraph 2 speaks, "Motherhood and childhood are entitled to special care and assistance. All children, whether born in or out of wedlock, shall enjoy the same social protection." Likewise, the International Covenant on Civil and Political Rights in its Article 24 speaks about, "Every child shall have, without any discrimination as to race, color, sex, language, religion, national or social origin, property or birth, the right to such measures of protection as are required by his status as a minor on the part of his family, society and the state." There are scores of international legal instruments that has dealt with the varied rights and entitlements of children, beginning with the 1924 Geneva Declaration of the Rights of the Child during the period of the League of Nations. This was in fact the first major international document which clearly spelled out that whatever is the best possible available facilities shall be made available to children in their settings. Similarly, after the enactment of the UN Charter and the establishment of the United Nations, the UN Declaration of the Rights of the Child in 1959 was adopted by the UN General Assembly. 30 years later, the UN Convention on the Rights of the Child was adopted by the General Assembly again, and this UN Convention on the Rights of the Child was followed by 3 distinct optional protocols which are attached to this main convention. The first optional protocol of the year 2000 to the Convention on the Rights of the Child focused exclusively on the sale of children, child prostitution and child pornography issues. This optional protocol was essentially an expansion of the main principles initially drawn up in the UN Convention on the Rights of the Child. And the second optional protocol of the year 2000 dealt with the question of the involvement of children in armed conflicts, once again expanding upon the provisions which are available under the UN Convention on the Rights of the Child. In the year 2011, the UN Convention on the Rights of the Child again got a third optional protocol attached to it, and this particular optional protocol deals with a communication procedure available to children to complain to the international human rights body, institutional mechanism that is established under the UN Convention on the Rights of the Child for the purpose of realizing their rights in the countries which have become parties to that particular optional protocol. There are scores of other international instruments which also talks about the rights of children in other settings. For instance, the International Labour Organization adopted the Minimum Age Convention in 1973, prescribing the minimum age that shall be maintained by countries in the employment related activities. for the purpose of regulating the usage of the employment of children in hazardous industries and other occupational problems for the children. There are also international conventions of a private law nature. For instance, the civil aspects of international child abduction has been regulated under the Hague Convention of 1980, which came into force in the year 1983. In the year 2000, the ILO Convention concerning the prohibition of and immediate action for the elimination of the worst forms of child labor is one significant international document in this connection. In the South Asian region, we have a number of conventions which deal exclusively with the problems associated with the children. For instance, the SAR Convention on Preventing and Combating Trafficking in Women and Children for Prostitution. This is adopted in the year 2002. Likewise, there was also a regional arrangement for the promotion of child welfare in South Asia, which was again adopted by the SARC Ministerial Conference. Likewise, in the European region as well, we can see that international conventions have been adopted for the purpose of recognition and enforcement of decisions in matters of custody of children and restoration of the custody of children. This has been necessitated by the practice of parents, or most of the time one of the parents taking away one child from the custody in a transnational context. In the American region, the Inter-American Convention on the Return of Children was signed in Montevideo on 15th of July 1989. This convention has not come into force. Similarly, UNICEF has adopted a document for the African region, Cape Town Annotated Principles and Best Practices on the Prevention of Recruitment of Children into the Armed Forces and Demobilization and Social Reintegration of Child Soldiers in Africa in the year 1997. This was adopted in a context where several states in Africa, where military as well as non-military persons were using children for the purpose of as child soldiers. Likewise, in the Council of Europe, adopted a convention on the protection of children against sexual exploitation and sexual abuse in the year 2007. There are significant issues associated with the rights of the child. From birth onwards, issues of children come into existence. The very survival of children, their protection at varied settings and development and participation in issues relating or issues of interest to them are some of the major concerns that have been addressed under the rights of the child. The right to life and health, right to education, in a context of violence against children, sexual and other exploitation of children, issues of juvenile justice, inequalities in society, poverty, disability, disparities of access to services, the divide between rural and urban communities, discrimination in the face of unequal access to societal resources, the problems of the disabled, problems of the girl child, female foeticide, infanticide, female genital mutilation in many parts of Africa, vulnerabilities of ethnic and religious minorities in a context of majoritarian assertions in several countries, and finally the question of armed conflicts impacting upon children, the question of child soldiers, refugees and other vulnerable situations. All these are some of the most important problems that children of the world face in their varied human and political settings. It is in this context that we need to look at the UN Convention on the Rights of the Child as a legal instrument enacted for the purpose of attaining a common standard for the world's children, for asserting their rights in an international context, for the purpose of realizing them in their varied national settings. The Convention on the Rights of the Child was adopted by the General Assembly of the UN in the year 1989. In November 2014, the UN Convention on the Rights of the Child marks its 25th year of existence. A quarter of a century has passed since the convention was adopted. It's now the most widely ratified human rights instrument and one of the most important international law instruments ever to be drafted by the international community. As stated before, the convention has 3 optional protocols as well. One of them deals with the question of sexual trafficking of children. The other deals with the problem of child soldiers, and the third one deals with an individual complaint mechanism or a communication procedure. The UN Convention on the Rights of the Child has 54 articles in total. Articles 1 to 41 deals with the substantive principles describing the specific rights of children, the majority of which impact upon the services provided by the national authorities or the local communities. The final part of the convention deals with the implementation mechanisms, how the UN and the state parties work to ensure that these rights are realized in the context of children. There are several key features which one can identify from the Convention on the Rights of the Child. A child is to enjoy special protection as well as opportunities and facilities by law and other means. Paramount consideration in welfare legislation and state policies is for the best interests of the child. In adopting legislative and administrative measures impacting upon children, the state has all the time keep in mind the best interests of the child. And the convention also has brought up an institutional mechanism for overseeing the working of the framework which is enunciated under the convention. For instance, the Committee on the Rights of the Child has been made the depository of reports by state parties, and this committee has got the right to come up with the general comments based upon the experience of the working of the convention rights. General comments are those expert opinions which are issued by the committee, and this aims to provide state parties with an authoritative interpretation of the rights contained in the articles and provisions of the convention and its optional protocols. The comments contain guidance with respect to particular issues and assist states in understanding how to fulfill their treaty obligations. There are a number of basic principles which emerge from a reading of the convention, and the rights regime under the convention can be organized under 3 distinct domains. One is relating to the provision of services such as education or healthcare, and the second component can be classified as belonging to the protection of children and young people, such as protection from abuse or from dangerous drugs and other things. So there is a state obligation relating to the protection of children from those dangerous drugs. And thirdly, the rights relating to the participation. This is basically to recognize the evolving capacities and the rights and obligations as understood by the child himself in issues and concerns pertaining to their own future and special interests. There are 4 distinct principles which are to be adopted by the state parties in all issues relating to the rights of the child. First, one of the overarching principles is the obligation of non-discrimination. And secondly, in all policies, best interest of the child has to be kept in mind. Thirdly, right to life, survival and development of the child has to be a major priority in all issues dealing with the children. Fourthly, respect for the views of the child with his evolving capacity and ability to suggest what is best for him should be taken into consideration in administrative and judicial proceedings. There are a number of substantive rights which are available to children, and the Convention on the Rights of the Child gives a legal sanctity to those substantive rights of the children. A child is entitled to a name, birth registration and nationality. He is entitled to adequate nutrition, housing, recreation and medical services. A child has the right to education, freedom of expression and the right to practice his or her culture in association with other members of the family and community. There is a right to protection against neglect, cruelty and exploitation, trafficking, underage labor and discrimination. The right to a fair trial and the right to be heard in proceedings that affect them. And vulnerable groups of children such as refugees and the handicapped are entitled to special treatment, education and care. Many of these rights are available to adults, and international human rights law has already given sufficient ground for asserting these rights in the context of adult human beings. And the Convention on the Rights of the Child essentially draws upon these existing frameworks for addressing the concerns of children as well. One of the principal protocols which is attached to the UN Convention on the Rights of the Child is the Sex Trafficking Protocol. This optional protocol has been widely ratified, with over 166 countries becoming part of this protocol. It deals with the sale of children, child prostitution and child pornography. States are under an obligation to prevent and prosecute whoever is indulging in these practices in their national jurisdictions. This optional protocol essentially builds upon Articles 34 and 35 of the Convention on the Rights of the Child. There are broad protections available under those provisions against child trafficking, sexual exploitation and abuse. And this optional protocol legally defines and prohibits the sale of children and child prostitution and child pornography. Protection of and assistance to the victims in the criminal justice process, including procedures for seeking compensation for damages from those legally responsible for protecting them, has been enshrined in this particular optional protocol. It also provides a base for the state parties to assert their jurisdiction over actionable practices and also strengthen their ability to pursue extradition of offenders who are fugitives from the legal system and finding themselves in a transnational context. The second optional protocol attached to the Convention on the Rights of the Child deals with the question of children affected by armed conflict, especially the child soldiers, the so-called child soldiers. This convention once again is a widely ratified international legal instrument, and it pertains to the involvement of children in armed conflicts. Many of them have been taken into custody by, most of the time, both the state as well as non-state actors in varied contexts. We have heard a number of literature speaking about the problem of child soldiers in the Sri Lankan Civil War, when the LTT used to indulge in this practice of using children for the purpose of soldiering in the civil war against the Sri Lankan government. Considering the harmful impact of armed conflicts on children, international law condemns the selective targeting of children in conflict situations. It criminalizes child recruitment for warfare and also defines important terminologies such as conscription, enlistment and use, and also evolved the new legal doctrine of individual culpability through joint criminal enterprise for indulging in the aforesaid offences. So, there is a parallel with the development of international criminal law in a number of international legal instruments which came out in the last decade, including the Rome Statute of the International Criminal Court and also the Statute of the Special Court for Sierra Leone, establish conscription of children as a violation of international humanitarian law, thereby constituting expanding the definition of war crimes to include the conscription of children for soldiering in an armed conflict situation. And the third optional protocol deals with the question of communication procedure. This was adopted in the year 2011. It essentially seeks to empower the children to have access to international human rights bodies. And it allows the receiving and examining of individual complaints from children. And this will be a new way of looking at the implementation of state obligations on children's rights. The mechanism will shed new light on the interpretation of children's rights in a context where children will complain to the international human rights mechanisms which are being established for the purpose of realizing children's rights. The Committee on the Rights of the Child can undertake country visits where there are allegations of systematic and recurrent violations of children's rights. This will further expand options for accountability in those settings. Now we shall look at the work of the Committee on the Rights of the Child, which is the institutional mechanism established under the Convention on the Rights of the Child, to look into the reports of the state parties, issue general comments, and also to receive the communications which are available, which are being directed by the children to recognize and realize their particular rights in a national context. First of all, the Committee on the Rights of the Child is an expert body of mostly 18 experts who are appointed under the convention into the Committee on the Rights of the Child. It forms a vital institutional mechanism for interpreting and clarifying the nature of legal obligations of states in the implementation of their international obligations in relation to children's rights. The committee receives periodic reports from state parties informing it about the progress in the implementation of the convention and the legal and administrative measures taken in furtherance of the related legal obligations. The committee examines the report and records its suggestions. The committee examines the reports of the state parties and records its suggestions and recommendations for further actions by the state parties that submitted the report. In assessing the situation of children in the states in question, the committee often holds pre-sessional discussions with international organizations and other NGOs working on the ground. In short, the consideration of state reports on national implementation forms a primary mandate of the Committee on the Rights of the Child. It's interesting to note the observation made by Ms. Kristen Sandberg, who is the chairperson of the Committee on the Rights of the Child, in a speech at the UN General Assembly on 16th October 2013, and I quote, she says, through our work of examining reports from state parties, we see some encouraging improvements in government's awareness of children's rights and their willingness to implement them. There are many good efforts and results, not only in areas like health and education, but also with regard to child participation. However, the variations are great and there are some disturbing developments. Violence is still widespread in the family, in schools, in institutions, as is sexual and other forms of exploitation. There are disparities between rural and urban areas and inequalities affecting children in poverty and other vulnerable situations. We see discrimination of children with disabilities, girls, children of ethnic minorities, and large-scale unnecessary placement of children in institutions, as well as unaddressed issues in juvenile justice. And as we know, in times of conflict and crisis, children are the ones worse off. It is all the more important to strengthen children's individual rights. Based upon the work of the committee, the chairperson has been observing about the varied conditions of the fate of children in different countries of the world. The Committee on the Rights of the Child issues general comments. These are based on the experience of working with state parties and examining their reports over the years. The committee issues its general comments with the objective of providing recommendatory guidelines. It is to provide state parties with an authoritative interpretation of the rights enshrined in the articles and provisions of the conventions and the optional protocols. The comments contain guidance with respect to particular issues and assist states in understanding how to fulfill their international obligations under the respective treaty. The committee has so far issued 17 general comments over the years, including 4 which were issued in the year 2013. And finally, we are talking about the individual communication procedure available under the 3rd optional protocol. This optional protocol came into force this year on 14th of April 2014, and it has gained the required number of ratifications for the protocol to come into force. The period of time stipulated in accordance with Article 19, Clause 1 of the protocol reads as follows, and I quote, "The present protocol shall enter into force 3 months after the deposit of the 10th instrument of ratification or accession." So far 11 countries have ratified the 3rd optional protocol. Hence, the 3rd optional protocol regarding communication, individual communications, has come into force, and the committee is now empowered to receive complaints from children from those countries which have ratified this particular 3rd optional protocol. The Committee on the Rights of the Child thus enters a new stage of progress in its endeavor to promote children's rights internationally, and with the possibility of commencing on communications and complaints likely to be received from children and NGOs on various complexities involved in the working of treaty rights and obligations. The committee will have the opportunity to visit those countries to study the situations in their context, to frame new procedures for realizing those rights in those specific circumstances of the children concerned. These are all important new breakthroughs for the advancement of children's rights at the interstate level. And in guiding its work in relation to the devising of procedures for dealing with these new and emerging area of individual communications, the Committee on the Rights of the Child can certainly take advantage of the kind of experience that has been gained under other international human rights treaty bodies which are already in existence in this regard. Now we look at the role of the state parties or the states which have signed on these international legal instruments for the protection and promotion of children's rights in their countries. Article 4 of the Convention on the Rights of the Child is explicit in this relation. It states that state parties shall undertake all appropriate legislative, administrative and other measures for the implementation of the rights recognized in the present convention. With regard to economic, social and cultural rights, state parties shall undertake such measures to the maximum extent of their available resources and where needed within the framework of international cooperation. So, beyond ratifying the Convention on the Rights of the Child, the state parties have an important role and primary obligation in the implementation and application of children's rights. There is a legal expectation that the state parties shall take all appropriate measures, including legislative, policy and administrative measures necessary for the implementation of the obligations emerging out of their international commitments. We shall presently examine India as a state party to these international obligations, also in a context in which India has constitutionally committed itself to the promotion and protection of children's rights. We have a number of constitutional norms which commit our country to the protection and promotion of the rights of the child. Several provisions under the Constitution of India address the issues which are most relevant for the condition and situation of children. For instance, the amended Article 21A deals with the right to education. Now, there is a right to free and compulsory education for children up to the age of 14, and this is a fundamental right which cannot be derogated upon by the state under any circumstances. Article 24 of the Constitution pertains that to the issue of hazardous employment. No child below the age of 14 shall be employed to work in any factory or mine or engaged in any other hazardous employment. Likewise, Article 23 prohibits the trafficking of human beings and forced labor. Similarly, the directive principles on state policy, especially Article 39 clause E and F, that deals with or directs the state to ensure that children are given opportunities and facilities to develop in a healthy manner and in conditions of freedom and dignity, and that childhood and youth are protected against exploitation and against moral and material abandonment. So, the state it's one of the directive principles of state policy in the Constitution of India that the Indian state is committing itself to the protection of children and promote their interests in the varied contexts. And Article 47 imposes on the state the primary responsibility of ensuring that all the needs of children are met and that their basic rights are fully protected. Now, we shall look at India's engagement with the international law as a state party to several legal instruments for the purpose of realizing the children's rights. How much India has become a party to various international legal instruments which are recognizing the rights of children. And in the last decade, we can see that there are several instruments to which India has become a party. In 1992, India was one of the first states to become a party to the Convention on the Rights of the Child in South Asia. In the year 2002, India has signed the SAARC Convention on preventing and combating trafficking in women and children for prostitution, and also the SAARC Convention on regional arrangements for the promotion of child welfare, as we have already noted. And in the year 2003, India ratified the Hague Convention for the protection of children and cooperation for inter-country adoption, which was initially adopted in the year 1993. In the year 2005, India ratified the optional protocol to the Convention on the Rights of the Child, dealing with the sale of children, child trafficking, child prostitution, child pornography, etc. And in the same year, we also ratified the other optional protocol relating to the involvement of children in armed conflict, basically committing India from following the path of those countries or non-state entities which have used children for the purpose of soldiering and conscription in the armies, etc. And in the year 2007, India ratified the UN Convention on the Rights of the Persons with Disabilities, and this convention has substantial provisions relating to the rights of children with disabilities, in a way committing India to the promotion of the interests of the disabled children at the national level. And we have taken a number of implementation measures at the both legislative and administrative measures which seek to advance the international commitments that India has already made in this context. For instance, the Commission for the Protection of Child Rights Act was enacted in the year 2005, essentially giving effect to India's obligations under the Convention on the Rights of the Child. And there have been amendments associated with the Juvenile Justice, Care and Protection of Children, and the Prohibition of Child Marriage Act, Right to Free and Compulsory Education Act, the Protection of Children from Sexual Offences Act, and all of these were followed by a national policy for children in the year 2013. Now, examining India's implementation record, we can make several observations. India faces enormous challenges in translating its demographic advantage of having one of the largest number of children in the world within its territory. At 472 million and counting, nearly every fifth child in the world lives in India. While the country has achieved progress on many fronts, the full record of child survival, extent of malnutrition and underdevelopment continues to paint a graphic picture of deprivation, malnutrition and stunted growth, which is apparent from the statistics dealing with the over 40% of India's children are malnourished and stunted growth. And despite the oft-stated objective of converting the substantial young population into productive economic assets, productive national assets, this is not borne out by the record of low budget outlays and poor implementation record at the ground level. Although children constitute nearly 40% of the national population, the budget outlays seeking to improve their specific situation and special vulnerabilities are at less than 6% of the GDP. Likewise, as a nation with the fifth world population of children, India's record of progressive realization of children's rights against a backdrop of poverty and deprivation constitutes an impressive achievement. There is little doubt that the Indian state has made enormous progress in realizing the rights of children despite the contingencies associated with the diversity of the country's economic and regional profile. The recent legislative initiatives as well as the official policy statements in India are thus reflective of both its domestic commitment and international obligations for the welfare of children. Given the huge diversity and numbers involved, the larger challenge is to ensure that the available resources are effectively deployed to transform the grim reality of widespread deprivation and denial of children's rights in India. The relative disconnect between legal recognition of children's rights and their effective realization at the ground level among the marginalized sections of the Indian society, it calls for thoughtful implementation of agreed policies and adopted strategies. In conclusion, when we look at the big picture of children's rights under international law, it is apparent that international protection of children's rights has progressed forward ever since the adoption of the Geneva Declaration of the Rights of the Child in the year 1924 under the League of Nations. There is a global consensus and impressive ratification record testifies to that that the basic rights of children everywhere needs to be protected and strengthened at the global level. Every child, irrespective of origin, sex, language, religion or status, can and should be able to enjoy the rights enshrined under the Convention on the Rights of the Child and other international human rights treaties. As an expert noted in the context of the UN Millennium Development Goals and the associated children's issues, a world fit for children will be one in which all children in all societies grow up healthy, well nourished and educated, and are fully protected from environmental risks and hazards as well as from violence, abuse and exploitation. Children will be major stakeholders in and contributors to a sustainable world as well as its future custodians. Indicators of their survival, protection and development will be critical to the success of any international development agenda that is being adopted in the years to come. And compliance with the substantive norms of global child law, however, shows uneven progress across societies. When we compare the situation of achievement across societies, we see that there is uneven progress. To build on the existing progress in national implementation, careful scrutiny of the remaining challenges is a key strategy. Systemic intervention at different levels of the implementation chain, from the allocation of resources, adequate budgetary outlays at the state level to the creation of institutional frameworks at the local community level for awareness building and for realizing those rights at the ground level. These are significant components of any such strategy which needs to be looked into by the states concerned. International institutional oversight mechanisms such as the Committee on the Rights of the Child and other human rights bodies with a mandate to look at the vulnerabilities of children in varied contexts need to be strengthened. They can contribute to the cause of incremental advancement of children's rights, strengthening their hands both substantively and procedurally should be the way forward for the purpose of dealing with the already identified issues and challenges in the realization of the rights of the world's children. Thank you.